2, 1.
Oh, yay, oh, yay, oh, yay. The Honorable Court of Appeals of Tennessee is now in session. God save the United States, the state of Tennessee, and this honorable court.
Good morning, counsel. Before we start, a couple of things. One, we don't anticipate any technology problems, but if we should have a problem, everybody just take a deep breath and we'll pause, and our folks who know how to correct it will correct it. I think, and before we call the case, Judge Firestone has something he wants to bring to your attention.
Thank you, Chief. One announcement. I anticipate that next week, Mr. Patrick Rader will be transitioning to my office as administrative law clerk. It's also my understanding that Mr. Patrick Rader is related to Mr. Rader in this case. That has no bearing with regard to my sitting on this panel and addressing the appeal. Mr. Rader will have no contact or involvement with the case in my office, and I'm prepared to go forward and participate with this panel on this appeal unless there is any concern or objection. I wanted to disclose that on the record, Chief. That's what I wanted to bring to everyone's attention.
All right. Counsel, any difficulty with that at all? With Judge Firestone sitting?
None at all. No objection.
Not for me either. I know Patrick is very excited about this new opportunity. So
he should be. He was a good judge. All right, call the case, please.
Carolyn Diane Long versus Stephen Lawrence Long.
We'll hear from the appellant.
Thank you, Honor. My name is Eric Birch of the Coffee County Bar. I represent, along with my law partner, William Lockhart, Carolyn Long, in this appeal in the Eastern District. This is a fairly long-term marriage. This is the second appeal of this matter. Your Honors, this court previously heard this case in 2019 and issued an opinion basically finding that the trial court failed to make the appropriate and necessary findings of fact, and Your Honors remanded the case for additional findings of fact. There was what appears from the transcript to be a very short hearing. Neither Mr. Rader nor I were involved at any of the proceedings with the trial court, with the exception of a minor motion that occurred after the notice of appeal had been filed. But we weren't involved in any of the substantive proceedings before Judge Warner. We have cited several issues. The first issue is whether Judge Warner, even after the remand, made the appropriate findings of fact, inasmuch as Judge Warner simply regurgitated the findings of Mr. Long's counsel in the order that he submitted. It was verbatim, word for word, with the order submitted by Mr. Long's counsel. I don't really want to focus on that issue for the purposes of oral argument. I will simply rely on the brief with regard to that issue. The fact is, we really don't want this case remanded. This divorce has been going on for almost 7 years now. We would like the case decided one way or another. And really, there's only one issue that we're focusing on, or one particular property we're focusing on with regard to this appeal, and that has to do with a partnership called Pioneer Properties. Pioneer Properties was, we contend, a gift from my client's stepfather and mother to herself, siblings, and I guess they'd be step siblings, and she owned a 1/3 interest in Pioneer Properties. The only testimony that was given with regard to Pioneer Properties, as opposed to whether it was a gift to my client or a gift to the marriage, because it's uncontroverted that stepfather and mother are the ones that funded this, began this, and all the funding and everything came from them. The only proof with regard to whether it was a gift to my client or a gift to the couple is there were testimonies from my client's mother, who was the one making the gift, and my client's, I believe it was her stepbrother, may have been the brother. They all testified that this was a gift to my client back in 1993.
Excuse me for interrupting, counsel. It's my understanding that in the order, the trial court made specific credibility determinations. Is that correct?
That is correct, Your Honor.
How would that impact this issue on appeal?
There was really no proof that Mr. Long submitted that stated this was a gift to him. The brunt of his proof was that while this may have been a gift, it was transmuted or commingled with his efforts, and monies were deposited into a joint bank account, and that somehow commingled and transmuted the entirety of the Pioneer Properties property. And that goes back to the first issue I cited with regard to the findings of fact that Judge Warner did provide. They were verbatim in lockstep with the findings that Mr. Long's attorney submitted. There were no oral statements, no oral rulings, anything of that nature that indicated anything about credibility. We believe he just simply regurgitated what Mr. Long's counsel submitted, which is inappropriate under Cunningham versus Eastman Credit Union. We don't think that the court should place a great amount of weight upon those, given that there was nothing in the record that showed that those findings were independently made.
Well, counsel, I mean, the court stated in its order that it was or didn't the court state that these were its independent findings and that these are consistent with the court's findings? I mean, the court stated that, didn't it?
It did state that, Your Honor, but just the appearance of simply regurgitating what defendant's counsel submitted, I think that detracts from that. But nevertheless, the only proof was that it was a gift. There was testimony from 3 different parties, 3 different people, that it was a gift. I think the court's order questioned Miss Long's credibility. That those findings did, but I may have missed something, but I don't think it questioned really the credibility of her mother or her brother or stepbrother. Again, the brunt of their proof seemed to hinge on the fact that, or hinge on the premise that Mr. Long somehow contributed to the appreciation and improvement of this entity. And the only proof that we have with regard to that is he maintains that he showed a few of these properties for sale in his capacity as a realtor. But the proof with regard to that was he was compensated for those. If the property sold, he was paid a commission on those. He testified that he mowed a few of these properties. But the proof was that while he did mow a few of these properties anyone could have mowed these properties, and he was paid for that. He was paid for mowing. He was never listed as a member of the partnership. He was never put on any partnership accounts. He wasn't included in the partnership meetings. He states that he valued a few properties with my client's father, stepfather, and her brother, who were also realtors. Him simply chiming in an opinion, in my mind, that does nothing to enhance the value of the underlying partnership. Judge Warner seemed to place a lot of emphasis on the fact that distributions from the partnership were placed into the partnership or into the party's joint account. I would submit that that's irrelevant. Simply because my client she was given a distribution, she chooses to put it into a joint account, does nothing to the underlying asset of Pioneer Properties. She could have taken the distribution for Pioneer Properties, which was her separate property. If she got a distribution from that, she could have placed that into her own separate account. And if she had never commingled that, that distribution would have been her separate property. She chose not to do that. The distribution itself, indisputably, the $70,000 or so that was distributed, we're not disputing that distribution became marital property. We simply dispute that does nothing to the underlying asset. I think I'm out of time, so I'll reserve the remaining 5 minutes for my rebuttal.
Thank you. We'll hear from the appellee.
Thank you, Your Honors, and may it please the court. I'm Danny Rader, and on behalf of the appellee in this case, and I want to echo Mr. Birch's comments. My client is anxious to get this resolved. This divorce has been going on since 2014. We appreciate the court hearing this, and hope that when your opinion is written, that it will resolve all issues in this case and conclude this chapter of the parties' lives. Opposing counsel perhaps misapprehends part of my client's position. My client disputes the existence of a gift. The Pioneer Properties partnership interest. Pioneer Properties was created in 1993 during the marriage, and so the presumption arises that it was marital property. The appellant has the burden of proving, and I submit by clear and convincing evidence, that the partnership was a gift to her in order to make it separate property. She's not articulated any other basis that it would be separate property, simply that it was a gift. And I would submit to the court that the evidence preponderates against the finding that it was a gift, which is why the trial court correctly ruled that it was not a gift. And that's true whether it's the preponderance of the evidence or the clear and convincing evidence standard. As your honors know well, and it was discussed, I think, really in the principal appellate opinion that I know Judges McCarty and Frierson participated in. Judge Susanna wrote the opinion. The elements of a gift are the present intent to donate and surrender of the dominion and control over the property. And it's necessary to prove a gift by the totality of the circumstances. So all of these things are relevant with respect to the distributions of the money and other things like that. But I'd highlight to the court the very first exhibit to the first trial, which is in the record, exhibit number 1 I got the record electronically, and it's labeled exhibits supplemental 1, but it's exhibit number 1. It's the partnership agreement to Pioneer Properties, dated in 1993. And it has 5 partners listed. And the partnership agreement specifically says on page 2 of this exhibit number 1, all partners agree that each individual partner has contributed equal amounts of either labor, expertise, personal property, or real property to the partnership, and that each partner's capital account is presently equal to all the other partners' capital account. It further says that if any other monies, personalty, or real property are contributed or make their way into the partnership, that it will be deemed a loan to the partnership to be repaid out of partnership funds. At no point does this partnership agreement reflect that there was a gift or any intent to have a gift. It is signed by the appellant, Diane Long, and it contradicts any testimony by Ms. Long that her interest in this partnership was anything other than what her written contract says, which was her contribution of equal value,
Was there other testimony on that issue?
So the testimony in this case was really short, and I was surprised by it. The testimony during the first trial, there were 3 trials. There's a first hearing that addressed solely to Pioneer Properties, which is whether it was marital or separate. The only testimony in that hearing at all was Mrs. Long and Mr. Long. And they had a second trial where they divided up the marital property. And then they had on remand, after Your Honor's opinion previously, they had another hearing, and that's when Mrs. Long introduced additional testimony, which was the testimony of her mother, Linda Waldo, and her brother, Steve Robinson. Ms. Waldo's testimony is less than a page in the record in total, and all she says is that she and her husband at the time, who was Ms. Long's stepfather, gifted the property to Ms. Long, gifted the interest in the partnership to her. But that contradicts the written contract. And Ms. Waldo is not a party to the original partnership. She's not listed in the original partnership agreement. So she testified, I guess, that she's the donor, but she's not even one of the partners. She and the contract says that all of the partners agree that each partner has contributed equal amounts of the property. And so Ms. Waldo's testimony contradicts the contemporaneous written agreement. And of course, you expect Ms. Waldo to testify in support of her daughter in her divorce case. If that is sufficient to carry the burden of proof of a gift, whether by the preponderance of the evidence or clear and convincing, no divorce is ever going to be resolved against the gift, because the spouse who wants to keep the property and their mother is always going to testify for them. There was no other contemporaneous documentation provided. Ms. Waldo was asked on cross-examination if a gift, and all of the witnesses were, if a gift tax return had ever even been prepared or filed, or whether any gift tax had been paid. And on page 32 of the transcript where Ms. Waldo testified, again, her whole testimony was barely a page. The question, have you ever filed a gift tax return? Her answer, not that I know of. And so if there were a gift, one would expect a gift tax return to be filed. And if one weren't filed, it would probably be a violation of the Internal Revenue Code section that I cited in my brief. So it'd be a crime that the court would be enforcing. Again, the proof of gift is the totality of the circumstances. So look at the totality of the circumstances. We have a written agreement that says that there's no gift. We have a written agreement that says Ms. Long contributed her own money during the marriage, or value. We have no gift tax return was ever filed, and no witness suggested that any gift tax return had ever been filed. We have the fact that the money that was distributed from the partnership throughout its entire history, forever, was always, each time, contributed to a joint bank account, which supports that it's marital property and that the partnership was not a gift to her separately, looking at the totality of the circumstances. The wife testified that the partnership made money for the first several years, but that there were no distributions of money at all. It takes some connecting the dots with the testimony. As Mr. Birch said, I wasn't there. But as your honors know, when there's a profit in a partnership, as just a matter of law, the profit is reflected on the K-1, which is filed on the individual's personal tax returns. And since no money at all was distributed from the partnership for those several years, by appellant's own testimony, she had to pay whatever tax was due on that growth that she testified to from her marital assets. So that, again, supports the totality of the circumstances. And so all of those things weigh in favor of the finding that it was a gift. The only evidence of any kind that suggests that it was a gift was Ms. Long's testimony that she viewed it as a gift, and her mother's testimony that she was the donor, and her brother testified that he viewed it as a family trust. And of course, there's no trust was ever created, and trust is a question of law in Tennessee that it has to be created with the intent to create a trust. And so, and Mr. Robinson, the brother, had not been in the business for over 20 years. So that testimony does not even balance out under the preponderance of the evidence standard. The law on gift, I'd submit to the court, is settled in Tennessee that to prove a gift, it must be proven by clear and convincing evidence, which resolves all substantial doubt, and that the gift cannot be proven by the testimony of the donee. It really requires the testimony of the donor or some contemporaneous documentary evidence, some extraneous evidence. That was not provided here because, again, Ms. Waldo was not the donor pursuant to the written agreement that's exhibit number 1. Not even a signatory to it, was never a partner in it, at least for its first 10 years of existence. And so I'd submit to the court that that cannot possibly carry the burden of proof by clear and convincing evidence. Gift has always been by clear and convincing evidence. Appellant wrote a reply brief that suggested that all of my cases that I cited on this issue were not divorce cases, that they were just other gift cases under Tennessee law. And I looked back at my brief, and I suppose that's true on this point, but I did cite throughout the brief to the case, to the reported case from this court of Trezevant versus Trezevant, which is a 2018 case, 568 Southwest 3rd, 595. Cited it for numerous other topics. I didn't cite it on this issue, but Trezevant versus Trezevant is a lengthy opinion about a wealthy husband and wife in Memphis. And it does address gifts specifically. And it specifically says in the divorce context that a gift does have to be proven, like any other Tennessee gift case, by clear and convincing evidence. So I'd submit to the court that wife has not carried that burden of proving that it's a gift. Again, the presumption is it's marital since it was acquired during the marriage. She bears the burden of proof. I don't think she can even meet the preponderance of the evidence standard, much less the clear and convincing. Now, if the court finds that it was a gift, my client still contends that it's marital property by virtue of the doctrines of substantial and material contribution. Mr. Birch talked about his contributions during his argument, and I don't dispute that that's what the testimony was. He participated in discussing the values of the property. Wife's testimony and explanation for that activity was that, oh, they just were involving him as a courtesy. But in reality, he did the work. He went out and mowed the properties. He helped list and sell the properties.
Well, was he paid for that?
He was paid for some of the activities. I don't know. I don't believe he was paid for all of the activities, but wife is a real estate agent too. And she received a commission when she would sell properties on partnership properties. So I don't think that there's any difference between the two in that regard. And with respect to transmutation, again, the fact that the wife testified that the partnership was profitable for many years, that no money was distributed from the partnership for many years, that profit had to flow to her personal income tax, which had to be paid out of marital property. That, together with the fact that all of the distributions when they did start many years into the partnership all went into the joint account, I think are sufficient to carry a burden of transmutation as well, even if the court found that it was a gift originally. But I'd submit to the court, I think the evidence is so strong on the absence of gift that wife didn't carry her burden of proof on that the trial court is right. And as your honors did note, the trial court did make a credibility finding against the wife on this issue. We'd submit that the trial court was correct that her testimony was simply not credible, particularly when you look at the absence of the gift tax returns, the selective memory that's transparently obvious when you read the transcript. She vividly remembered anything that she claimed helped her, and then she couldn't remember anything else at all. So, I think the trial court was right on that subject. With respect to the findings of fact, we'd submit to the court that appellant submitted her own proposed findings of fact before the appellee did. Appellant submitted her proposed order before appellee did. Appellee had to respond to each of those things by submitting its material at all. And they're diametrically opposite, and it had to reflect the trial court's independent judgment in order to execute the order that it did. I know because I read the advance sheets how important these findings of fact are to this court, and that's been a significant issue. And that's why I raised the waiver argument and cited Rule 52.02. I looked at the Smith case. Of course, it's just a 2014 case, but it seems like a lot longer ago because there have been a number of cases on findings of fact since that time. On Westlaw, I saw just rough search over 300 of them. I think there are probably even more than that. I was surprised, though, when I researched that not a single case that I could find on Westlaw cited both Smith versus UHS and Rule 52.02, which requires or permits a party to come to a trial court and ask for additional findings of fact. No one has ever asserted, apparently, that I can find, that the party should be required to come back to the trial court first and ask for additional findings of fact before coming to this court. And I'd submit that a rule that requires a party to at least ask the trial court for additional findings of fact before coming to this court and appealing the absence of sufficient findings of fact makes sense. As Your Honor knows, this is a second appeal. The last trial was a year ago this week in this case. The first appeal took 14 months. And of course, that's just how long things take. It only takes a few days to get back in front of a trial court and ask for additional findings of fact, maybe 30 days at the most. By filing a Rule 52 and a Rule 59 motion, it extends the time for filing an appeal. And it would make sense for the court to apply its longstanding waiver rule, which says that you can't raise an issue for the first time on appeal without requiring the litigant to first ask the trial court for additional findings of fact, because it would resolve these cases much faster. Most of the time, the trial courts, in my experience, have been willing to make additional findings of fact when parties have come and specifically asked them to do it. If they're not willing to do it, that's fine. They can be appealed at that time. The parties raise the issue in the trial court, and this court can resolve it. And I think that Your Honors will hear a lot fewer cases on absence of findings of fact if the local litigants and the local bar are coming back to the court and asking the court to make findings of fact if they're dissatisfied with the findings that were there before coming to this court. It'll resolve cases faster because they'll be resolved in 30 to 60 days instead of a year on appeal. And I submit to the court that that rule makes a lot of sense. And I can't think of any reason that that rule wouldn't be applied, the longstanding waiver rule, on this issue when it's applied on so many others. And I can't find any case where that has been specifically raised except for this January 2021 case that appellant cited in their reply. But I believe that was a pro se person and it wasn't fully developed. Rule 52.02 was not cited at all. Thank you, Your Honors.
Thank you, counsel. We'll hear from the appellant rebuttal.
Thank you, Your Honor. With regard to the standard of evidence that's required, we have cited the case of Dunlap versus Dunlap, and that's in a divorce case itself. In that case, the question was, it was a similar issue, whether it was a gift constituting separate property. The court in the Dunlap case states that the burden is on the property claiming a gift, and it did not raise the standard in that case to clear and convincing evidence. Regardless of whether it's preponderance of the evidence or clear and convincing, if you look at the trial court's order, the trial court, who speaks through its orders, raised it to an entirely different level. The trial court found that the wife failed to prove that it was a gift indisputably, basically raising it almost beyond a reasonable doubt type standard with the word indisputably, stating that's what she had to do to prove it was a gift. We would submit that there is no evidence that these parties contributed anything. This was very early in their marriage. These parties were very young at the time. The only proof is that the principle that established this came from mother and stepfather. This happened almost 30 years ago. I can't speak to why they did or did not file a gift tax return, or whether they did or did not even do that. Mr. Long doesn't testify that they contributed anything to this property, to the acquisition of these properties. And again, whether the distributions, what happened to those, in my mind, is irrelevant to whether the underlying principle is separate or marital. Again, It's undisputed that those distributions, when they were deposited into the joint account, those proceeds, the distributions, transmuted. So we're not disputing that, and then presumably taxes were paid from the profits from that joint account. I will echo Mr. Rader. I was somewhat shocked by the lack of testimony in this case. This hearing on remand in a divorce that under anybody's valuations is worth well over $1 million. This hearing on remand couldn't have taken over 45 minutes about the time this oral argument would take. And I was somewhat shocked by the lack of testimony, how it was developed by both parties. But we have what we have here. We have testimony from 3 people. Even if your honors found that it wasn't a gift or that it had transmuted, at the very least, we would ask the court to take a look at what would constitute an equitable division of Pioneer properties. Again, we take the position that it's absolutely not marital property, but if it is, at least we need to take a look at what an equitable division of that property was. It's uncontested that it came from her family. She was the one that was involved in it. She was the one that was named in it. If he was a partner and his contribution was mowing the properties, why was he paid for it? His contributions to this were so sporadic and so meager that, and the court made an approximate 50-50 division of all assets in this case. We don't contest the other properties, but with respect to the Pioneer properties, that asset themselves, we think, even if it is marital property, a 50-50 division of that property is inequitable in this case. And I'm out of time, so I appreciate your honor's time. I appreciate you getting us heard on this issue.
Thanks to court's thanks to both parties for your brief and your oral argument. In this case, I believe we understand the issues and where we are. If clerk, if you'll please recess court till our next scheduled hearing.
This Honorable Court of Appeals is now in recess.
Thank you.